Welcome to the Challa weekly Wednesday webinars. And for those of you who are new, welcome. For those of you who've been joining every week, thank you so much for your support. And in just a second, we will go ahead and get started. Today, our focus is going to be on the flexibilities for F-1 students and kind of the mission shifts. There have been a lot of students that haven't gotten their work authorization, and so there have been some policy shifts in that I will discuss. So let's go ahead and get started. So there are a number of ways in which you can connect with me. You can connect with me on Facebook, you can connect with us on Twitter, Instagram, YouTube, LinkedIn, Telegram, and we'll have details about the Telegram shortly. And my team will put out all the links so you can connect with us in different ways, because we have mechanisms by which we are sharing information with people through different mediums. So make sure you connect with us on our social media. And if you happen to miss one of our webinars, you can watch them on our YouTube channel. We have everything from remote work to how to address RFEs, H-1B RFEs, how to structure a successful perm. So there's a lot of really good general information that you can avail yourself to. I want to remind everyone, if you have any questions, please put the questions in the Q&A instead of the chat box, and we will address the questions at the end. And so what are we going to discuss today? The shifting guidance for F-1 students, flexibility for the students has been announced. Is the USCIS returning to its original mission? That'll be interesting. And additional strategic considerations. And I'll tell you about a meeting I had yesterday where I told you I'm part of the API 100, where we're trying to structure the agenda for the Senate and giving them some talking points on key issues that we think need to be addressed. So I will have information for you on that. And I got an email stating that the House is looking for some assistance with drafting their legislation. So I'm going to be throwing my hat into that as well. And that's why it's really important that you connect. I mean, the only way I can be your voice is if I hear from you. And I can communicate the concerns that, the communities that are trying to find the American dream are, suffering through. And that's why you got to share it with your friends. Because if I'm able to say we've got, a group of 1,500, 2,000, 3,000 people who are talking about these issues, it makes it more powerful. Your message has a stronger voice. So please make sure you share our various social media platforms with your friends. Shifting guidance for F-1 students. Now, for the past several years, really, the policy and shift in the guidance has been disjointed among the announcement mechanisms. So litigation has shaped more flexible guidance, although challenges still remain. So active continuing F1 and M students may temporarily count online classes towards a full-time study. But you're only supposed to take one course per semester, 3 credits of online per semesters, and it prohibits M students from taking online classes. The temporary exception applied last year who were actively enrolled in schools on March 9th, and that was part and parcel because of the pandemic. So those outside the US are likely to be able to re-enter and remain in valid active status as long as they're engaged in a full course of online study. And also for those who are in the United States, but active students that are starting a new program for the educational level. So F1 and M1 students in the initial status after March 9th, who are outside the US, will not be able to enter the United States to enroll to a school that is fully online. There is still, if you remember, if you look back at my old webinars, there is a hybrid mechanism that they allow where it's partly online, partly offline. And that was because a lot of the schools started filing suit because they said, you know, we don't want to lose these great international students, but on the same token, the safety of our students, especially in a time of pandemic, is, you know, the most important issue. So that's why you've seen this kind of shift. So students that are still pursuing an in-person or hybrid course of study can remain in the United States, even if their institution later switches to a fully online program. Students on CPT and OPT, including STEM OPT, may work remotely inside or outside the United States when permitted and appropriate by their employer. The employer must assess the student's engagement using an electronic means. That means there still has to be optional practical training, and especially STEM practice, STEM OPT is really, they really want to see the training aspect. So without oversight, without input, that would not take place. So, you know, there has to be a mechanism in which the employer can provide input. SEVIS will now consider students appropriately engaged in OPT when they're working fewer than 20 hours per week within their active OPT opportunities. So that's another change. DOS has labeled student visas as a high priority. So they're trying to process the F1 students on a priority basis, even though, remember, there's still, depending on the country, there's still some shutdowns. DOS has expanded the authority of the consular officers to waive in-person interview requirements for individuals who are applying for a non-immigrant visa in the same classification. So several pandemic-related proclamations, President Trump's proclamations, well, presidential proclamations that bar U.S. entry of individuals that were physically present in China, Iran, Brazil, and the 26 nations of the Schengen area. UK, Ireland, South Africa, within 14 days prior to their entry. Students restricted by the proclamations impacting the Schengen, United Kingdom, and Ireland would automatically be considered for a national interest exception. Remember, there was that national interest exception for visas. And they didn't give guidance as to what they would consider national interest, but they had talked about in transportation or something related to the COVID relief. And we have found that in the past, there is something called a national interest waiver. So if you can meet some of those qualifications, you should be able to process the visa. The national interest exception does not apply to China, Iran, Brazil, or South Africa. As of January 26, 2021, all airlines arriving in the US, regardless of immigration status, are required to test negative for the COVID coronavirus via a PCR or an antigen test, no more than 72 hours before they depart. They were doing some of that even before, but now it's mandated. USCIS understands that, especially those that are looking for OPT and authorization, or STEM OPT, and the delays that all that has caused. So they haven't quite gone as far as I would have liked them to go. I would have liked them to say, okay, if you've got a receipt notice or proof that you filed, you can go ahead and use that for work authorization. But what they've said is that, you know, they do acknowledge that there are delays, not only with the OPTs, but even with, you know, EADs in general, due to the biometrics and so forth. But they are saying that they're trying to make sure that they have resources that are working overtime and to try to reduce the backlog. So students can typically participate in 14 months of OPT within the 14 months of completion date. But due to the lockbox delays, students were losing their eligibility time. So the USCIS is now allowing the 14-month to start from the approval date for the I-765 for post-completion OPT. And it will reflect the same amount of time as recommended by the DSO. So if it's 1 year, but it'll be 1 year from the date of the approval, which is good not only because it helps meet that 14-month guideline, but it also means that the person gets the full 1 year. And if they say if any students get a shortened approval, they can request a correction and get the full 1 year for their OPT. If some of the I-765s were rejected, students are given more flexibility in that area as well. They can file I-765 during certain timeframes. Lockbox delays caused timely filed I-765s that were later rejected because they were unable to timely refile within the time frame. So the USCIS announced, because remember they changed the lockbox address, so that caused some confusion. So the USCIS said that it will now accept a refiled I-765 for the OPT and OPT temp as filed at the original filing date if the original application was received on or after October 1st, 2020 through May 1st, 2021. So essentially, and USCIS subsequently rejected the timely file application. So if those two things take place, then they would accept a new application. Refiled applications must be received by May 31st to be treated as though they were filed on the original receive date. Copy of the rejection notice should be included to facilitate review. And there's no need to obtain new I-20s as long as the original one was submitted with the requested time frame. Within 30 days of the requested time, required time frames is 30 days of the DSO's recommendation for OPTs and 60 days of the DSO's recommended for STEM OPTs. Applications with missing signatures are usually rejected at the lockbox. That policy has not changed. If the lockbox accepts Form I-765 for OPT or STEM OPT with a missing or deficient signature, USCIS will issue a request for evidence rather than deny the application. Is the USCIS returning to its original mission? In 2018, USCIS revised its mission statement to remove the reference of the United States as a nation of immigrants and reference to customers. I mean, kind of saying, you know, we're not really a nation of immigrants, and we're not going to treat you as customers with that customer service kind of mind bent. The agency also rebranded the National Customer Service Center as a USCIS contact center and removed customer from the agency materials, such as the policy manuals in office, because they didn't want to have that customer-centric kind of focus. The original mission statement was the USCIS secures America's promise as a nation of immigrants by providing accurate and useful information to our customers, granting immigration and citizenship benefits, promoting an awareness and understanding of citizenship, and ensuring the integrity of our immigration system. This was unveiled as part of the first immigration reform scheme under President Bush in 2005. The current mission statement states the U.S. Citizenship and Immigration Services administers the nation's lawful immigration system, safeguarding its integrity, promising efficiency, and fairly adjudicating requested immigration benefits while protecting Americans and securing homeland and honoring our values. So those are buzzwords for saying, hey, we're not so into the immigrants coming in. This is what President Trump had put into his statement. So the new administration has rescinded a lot of the policies that reflect a negative impact on citizenship. In fact, they're reverting back to the 2008 citizenship test, effectively rescinding the computer programmer memo, which is Buy America and Hire America. And as we've talked before, they've now taken the word alien out. The Trump administration had, wherever there was foreign national, when the immigration regulations were first introduced, they called anyone who was not a citizen or permanent resident of the United States an alien. Later on, when we found that to be offensive for all the obvious reasons, the USCIS, whenever they initiated any new regulations, they would use the word foreign national. So the Trump administration tore out the word foreign national in all the regulations and replaced it with alien, which goes to the same kind of tone and tenor as protecting our homeland and the integrity of our values. So will the USCIS extend consideration to other categories affected by delay? So the next step, flexibilities for I-485 applicants. Lockbox delays continue to frustrate AOS applicants. There are erroneous rejections that we've been seeing, 8 to 10 week delays for some receipt notices, and the visa bulletin retrogression final action dates charged will be utilized again. I talked about removing the word alien. Family reunification policies, reversing the controversial asylum policies, the proposed U.S. Citizenship Act, which President Biden had introduced, and it's currently with Congress. As I stated earlier, for those of you who joined later, I'm working with a group to put together some talking points for the Senate to get an immigration bill passed. And I'm also planning to work with the House of Representatives as well. And one of the big pieces of issues that I keep bringing up is the backlog. So know that I am trying to make sure that those types of actions get addressed at that level. So additional strategic considerations. USCIS announced the effective March 1st, it will revert back to the civics test 2008 for anyone who filed before December 1, 2020, or anyone who files after 2020. And if you filed in between, you get a choice. And all interviews scheduled after April 19th, 2021 will be given the 2008 test, regardless of the filing date. The USCIS announced its first expansion of premium processing, and it was extended to E3 visas. So E3s, either whether you're filing an extension of an E3 or you're changing employers, you can file at premium processing. And we could see some more premium processing initiatives come up soon. Please remember, and if you've got friends that are in this process, that the H-1B season is open. Registration starts March 9th through 25th. The notifications will be sent out on who isn't been accepted on the 31st. And April 1st is the earliest date that we can file. If you're preparing for CAP registration, please email us at info@challalaw.com to request your free H-1B registration guide for employers. We're going to have a live H-1B CAP webinar to help people who are new to this process. And join us on the first day of the registration window, March 9th, for the H-1B strategy session. You should try to plan to register your employees before March 25th. And there's a lot of things you've got to keep in mind as you're going through this process. So the strategies are, what we're putting together is to help people have a successful H-1B selection process. So in crafting your immigration strategy for 2001, as I've said before, if you haven't started your PERM process, you need to do that. And I know people are saying that there's not a lot a high likelihood that the immigration bill would be passed, because technically you need just a simple majority, which they have, the Democrats have, but because of filibuster, the only way you can stop a filibuster, and that is where the opposing party keeps talking and talking and tries to delay vote of the bill, is if you have 60 senators who vote for the bill. And there are a lot of senators who are supportive of some of the things on the business side. I mean, it's gotten bipartisan support. And the president has shown his willingness to break it down into smaller sections if need be. So keep connected to us so I can keep you informed of what changes I'm hearing about. Like I said, we had a really good meeting. The woman that's spearheading this super caucus in the Senate actually worked for the USCIS for a number of years and then worked in the Obama administration. And so we're a group of 4 that are trying to put this together for the senators. And like I said, I'm also going to see how I can be of a resource to the House of Representatives as well, to make sure that, you know, sometimes as you're crafting legislation, what you think is a good idea may not make sense on ground and in application. So that's one of the things that we are trying to help them navigate as they go through this. And again, that is why your support is really critical. And we'll get to the Q&A in a second, but make sure you tell your friends about our Challa Chats forum. I know that my team has sent the links out. The only way you can have a voice is by the strength in numbers. So this is so I can help you. So I would really appreciate it if you can send it out to about 5 of your friends. And, you know, we work really hard to put this together. Specifically, you know, my team works really hard to put this together. I'm the face of it. And Kara Wood, in particular, does a lot of work to putting this together. So it would be really helpful for all of us if you could help us out in that small way, as we're trying to give you information and help you secure a positive immigration journey. And like I said, don't forget to look at our previous recordings of webinars. Anyone that's watched them have said that they've been really helpful, whether it's CSPA, whether it's other issues. They found it to really be a good resource for them. So please check it out, subscribe, comment. I love hearing from you, and please share with your friends. And if you have any topics you want us to cover, or you need to request additional resources, please email us at info@challalaw.com, and we'll be happy to help you out. I think we get on average anywhere from 30 to 50 inquiries per day on info, and my team is working really hard and diligently to get the information out to the people who have been requesting that guidance. So now we're ready for our Q&A and waiting for our moderator to join. There he is. Hello, Shekhar Challa. How are you today?
Good. How are you, Lakshmi?
Good.
Looking good.
Thank you.
The opportunity. Good afternoon, everybody. So let's set the stage for today. Request you to post your questions in the Q&A box. And while the attorney is asking for some clarifications or questions, then I'll be looking for those answers in the chat. So that's the order of business. So let's get on with our first person, Karthik Rajashekharan. Good afternoon. His question: why there is not movement regarding biometric or EAD in SRC location? I see significant movement in LIN/MSC, I stay in New Jersey, but application is SRC.
Mhm. Hi, Karthik, how are you? That is a good question. What happens is it just depends on resources and processes. It's historically been that way, that you have one service center that's moving a little bit faster than the other service center. And there's really no rhyme and reason for it other than on-ground resources. So they are trying, they have a firm that they're really going to make an effort to try to get the backlog addressed so that, and there are lawsuits that are still continuing. So I think we will see, you have to give it a little bit of time. They're dealing with a lot of things right now, but I think we'll see that there will be a movement soon. And I'm making sure that I keep emphasizing the need to address that as well.
Okay, the next question is from an AA. In the Telegram group Challa Chats E3, there was a recent video posted pertaining to employers think that E3s cannot file for a green card, and you have outlined the regulations in that video. I'm not able to open the video as it states that the video is private. Can you post it again?
Yes, I will do that. And I did that just because that is incorrect information. And what I am happy to do for any of you in the E3 group, if you'd like me to talk to your employer, I'd be happy to do that. But E3s are eligible for permanent residence. They do it all the time. It's in the regulations. So, and you can get extensions. And what's great now is strategically, there's a way you can do it because we've got premium processing. So talk to me, we'll make sure we repost that video, but let me talk to your employer and explain to them that whoever's been telling them they can't do that, that they are wrong.
All right. Next one is from another AA. I have applied for H1 and H4 EAD renewal together on July 10th. H1B is approved on November 10th, but H4 is still pending, whereas the fingerprinting is completed in September. I've also applied for an EB3 downgrade along with AP and EAD for me and my family on October 30th. It says October 30th, 2021, probably it means 2020. Receipt notices were received on January 19th. Our priority date is June 2013. Can we apply for premium processing for EB3 downgrade now or wait for the fingerprinting to be done? Please advise what's the best possible choice to make now.
Right. So two things. Number one, if you look at, I think it was our webinar last week or the week before, and Kara will clarify in the chat, where we talk about different ways in which you can contact the USCIS with any processing delays. So she will tell you what webinar that is and share that. Number two, you cannot ask for premium processing for a downgrade because remember, you don't have the perm with you. Now, once they have the perm, then you can do premium processing, but not till then.
All right. Karthik is following up. Is premium processing of EAD available?
Not for right now. I mean, they proposed it, but it hasn't been implemented. But let's wait and see there. Like I said, what they're trying to do is, remember, new administration has come in. A lot of the people that were there have gone. So it's this COVID. We've got, limitations on where people can work, and you've got new people coming in. I think once they have their that system in place, then they will probably expand premium processing to a number of others, including EAD.
Okay, next question from an AA. Once crossed 180 days of pending 485 and received approved I-140, what will happen if employer withdraws I-140 for downgrade? Any impact? Also moved to new employer after 180 days of pending 485 and approved I-140. what needs to be done for interfile to EB2.
Okay. Once the I-140, I think this was in President Obama's administration that they had published further guidance on AC-21. And in that, they clearly outline, and we've created actually a few posters that we're going to be posting up on the Telegram group with the resources and the law pursuant to that Obama clarification on adjustments. So if I-140 has been approved and 180 days has passed, and you are working for another employer in same and similar employment, even if your previous employer revokes your I-140, it does not impact your permanent residence.
Okay. Next one is from Towimba Howe. I'm planning to apply for asylum soon. I came to US in 2015 using L1B visa and expired 2018. I think that's all he has. So I guess he probably not. I think there's a follow-up. What would be legal basis to be approved for asylum? Is it possible to be approved for H-1B while out of status?
It's not possible to be on H-1B while out of status, but President Biden's legislation includes forgiving periods of status infractions. And so if that ever gets passed, that would be part of it. So you wouldn't be subject to the 3 or 10-year bar. But in terms of your asylum application, we would have to, I'd have to talk to you about that because it's very fact-based. So there's no general way in which I could tell you if you could be eligible. You know, asylum, and there's one other thing, if you are in love with a US citizen, even though you're currently out of status, technically you can file, they can sponsor you for permanent residence. But those are the only 2 ways if you have a status infraction. So email us at info@challalaw.com and we can chat a little bit about your asylum application.
All right. Sagar Kulkarni is on the call. Thank you, Lakshmi ma'am, for your help as always. A lot of my friends and family have benefited from your sessions. Can a derivative applicant use the AOS EAD and continue to stay on H-4? AOS EAD filed and H-4 extension also filed. Will USCIS reject H-4 extension if AOS EAD is used?
No, and that's part of what we've prepared. I hope, first of all, thank you. I'm glad you're friends and you have benefited from this. And, you know, please share it with your, more contacts so we can get more people to avail themselves of this information. But remember, H is a dual intent. So you can be an adjustee and an H at the same time. H4 is a derivative of the H1. H1 is a primary status holder. So the H4 can work on the EAD while they're on AOS and still maintain their H4 status without any problem.
Okay. Suresh Ukalakuntla. Any recommendations for F1 students applying for OPT now, considering the current processing delays? Thank you.
Well, I would go ahead and file now. If you've seen, like, I don't know if you joined us late, but earlier we talked about some flexibilities the USCIS is giving. So we'll be posting this webinar, I guess, later today. So I would take a look at that because that's all we talk about is the OPT and STEM and the flexibilities the USCIS has proposed. So if you are still eligible, that means you're still within the time frame of when the DSO authorized your OPT, then you should go ahead and file it.
All right, I just want to reiterate, I'm seeing a lot of questions on the chat. Like I requested, please put your questions in the Q&A. I got a question from Sai Kumar and Rahul on the chat. I will take it because I think you also put it on the Q&A, especially Sri Kumar, sorry. Vignesh Reddy has a question on the chat, so I'll take that when your turn comes, but please don't put it again in the Q&A. But all the rest of us, anybody who wants to ask a question, please put a Q&A in the in your question in the Q&A box. And what I was saying about chat was when the attorney is responding to your question and she has a clarification, she's asking you something, the response for that, you please put it in the chat because it's easy for me to look at that and tell her immediately. By the way, Mr. Tovimbe Hove, our email address is info@challalaw.com. That's where if you send the email, it goes to about 5 people. So you get a response pretty quickly. And our telephone number is 804-360-8482. Thank you. All right, let's look at another AA. I have filed for my I-539 on November 25th, 2020 for F-1. I still haven't been issued an appointment for fingerprint. During the course of it, can I file for an adjustment if I plan to get married to a green card holder? Please throw some light on that.
Well, technically speaking, F-1 is not dual intent. So if you have to, remember part of the F-1 issue is you have to intend to return to your home country. So I would, just out of an abundance of caution, wait till after the I-539 is adjudicated and then file for your I-130.
Okay. Sai Kumar, Sri Kumar, sorry, Sri, I keep saying Sai Kumar. I have a friend, Sai Kumar. I don't know why I'm thinking about him. I applied for 485, 765, I-131 in October 2020 and waiting for biometrics appointment. My final action date became current in March bulletin. My current H-1 is valid till the end of June 2021. I'm in the process of applying for my H-1 extension. My immigration department says that we can only request for 1-year extension instead of 3 years since my priority date is current. They say if we ask for 3-year extension, they might issue an RFE. Is that correct?
That is correct, because in order for you to avail yourself of at least the AC-21 provision that relates to I-140s, it says that the I-140 is approved and the I-485, I mean, your priority dates are not current. So they're trying to base it on the second AC-21, which is that your perm and or I-140 was pending for more than 1 year. I mean, so you're eligible for 1 year extensions, which doesn't have the priority date issue.
Okay. Next one is from Prabhu B. I'm planning to go to India next month. My visa expired 1.5 years before, so I have to go for visa stamping. Am I eligible for Dropbox option? And the second question is there any challenge or risk in visa stamping? And note, I am doing contract job in IT.
Okay, so when did his visa expire, did he say?
He didn't say, expired 1.5 years before.
Yeah, so you can do a Dropbox if you had a visa within the past 2 years, you're asking for the same classification and it's from the same country. Now, in terms of any risks, well, for IT companies, especially consulting companies, the biggest risk is making sure that you have all the documentation that clearly outlines that, the third-party placement work, the contracts, the letters from the end client, things like that. And if you have all of that, then that shouldn't be a problem. And make sure you read over your documents. So many times I hear consular officers say that the documents say one thing, but when the person comes in, they say something else. So make sure, that your documents that you read over your documents and you know what you're talking about when you go in. Then there shouldn't be, that you read over your documents and that it's consistent with what you're doing. And if that's consistent with what the petition says, then you shouldn't have a problem.
All right, Karthik Rajashekharan is back. Once crossed 180 days of 485 and downgrade I-140 approved EB3, can I still join new employer on H1 without EAD? As EAD is taking more than 11 months to get and is pending, will there be any problem with EAD once moved?
No. As long as it's same or similar employment, no.
All right, next question is from Prem Pathak. Will USCIS continue with the Trump era policy of rejecting H1 petitions with wage level 1?
They have rescinded a lot of them already. And they said that they would adhere to, because remember I think it was a federal court case on this that outlined that in and of itself cannot be a basis. And what we've done is when we've seen those challenges is say, and it's worked. I mean, we haven't gotten any denials based on level 1 wages where we said, this is a new grad. They were on OPT, optional practical training. They were undergoing training right before we filed the H-1B. So they should be at a level 1. And it's worked.
All right. Next one is from an AA. Received my AOS EAD last week. I need to go to India this month and want to use my AP card to enter USA. Once I'm back, want to change the employer. My question is, will the 180 days counted from received date, though I am outside USA?
Yes.
Okay. Another AA question. I do have H-1B visa stamped until 2020. Will there be any questions at POE while using AP to enter? Looks like it's the same person.
No.
Right. Sagar Kulkarni, can you interfile to EB2 after changing an employer on an approved I-140 downgrade to EB3? Can the new employer request an interfile to EB2? Note, I have an approved I-140 from the previous employer in EB2.
So if you want to interfile from the previous employer, then you have to, the I-140's got to be approved and you've got to wait 180 days before you can change employers.
Okay. So there's Vignesh Reddy. Vignesh Reddy is also on the chat. Vignesh Reddy is also here. So I'm not sure. I think there are two different questions or not, but I'll take Vignesh Reddy from the chat. First, I'm working for a firm on F1 STEM OPT. They applied H-1B and got it, but then I was laid off. I couldn't find another employer, and I'm still in US over the 60-day grace period, 2 months over the grace period.
Mm-hmm.
Can I change the status to F1 again by enrolling in another master's and crossing the Mexico border and getting back in again? My F1 visa is valid till 2022 July.
Yours is a rather complex question because you were in F1, you are DOS, duration of status. You're not in valid status in the US, so you can't change employers. I think there may be issues when you are out of status to go to Mexico or Canada. It's better to go to your home country and get a new F1 and come back in.
Okay. His question, Vignesh Reddy's question in the Q&A. Hello all, asking this on behalf of my friend. My friend was on STEP OPT and got his H1 approved as status stage H1. I think it's the same thing. He just put it in a different language. Okay, next one is AA. I have filed for my I-539 on November 25th, 2020 for F1. I still haven't been issued an appointment for fingerprint. During the course of it, can I file for an adjustment if I plan to get married to a green card holder? I think.
Yeah, we answered that.
Again. Karthik Rajashekar, it looks like this queue is missed question. I think we already answered that, so he's posted again. Towimbe Hove is asking, hi, is it possible to get approved for F1 while out of status?
No.
All right. And there's Rahul V in the chat. And I would request everybody to please submit your questions in the Q&A box. Rahul V is saying, after 180 days have passed pending 485 for starting new job, who files 485J, is it me or the new employer?
Yeah, the 45J is signed by both the employer and the employee.
Okay, his follow-up question is, does USCIS do GC interview when 485 is pending and priority date not current yet, or do they wait till the date is current?
They wait till the date is current.
All right, back to Q&A. Another question from AA. I have 2 months to recapture in L1A, my current visa. I have just submitted for COS and H4 EAD to Lockbox. Can I still go for extension for L1A? What will happen on my already submitted H4 and H4 EAD application?
What happens is that there's something called the last action rule. So whatever last action takes place, then that is the status that you would hold. So in this instance, the concern would be, and I'd have to know a little bit more. I mean, there is this idea that if you file for the L extension, you know, you'd be eligible for the 240-day rule, so you can continue working for 2 months on the L, and then later wait for the change of status to get approved. So I would do that in premium if I were you.
Okay. Another question from an AA. Can I be on FMLA on H-1B visa without pay?
If that's what the policy of the employer is, and that is what they do for all their employees, then yes.
Okay. I got a new person, Mithun Sunkara. Welcome. Can my employer file for PERM if I'm on F1 or need to wait till H-1B approval?
Can my employer file? No, you can file for PERM while you're on F1. And we've done that, especially with people where there's not a backlog. And remember, there may not be a backlog. Maybe, you know, if Congress passes the law to eradicate the backlog, then, you know, you'd be able to do this without a problem.
Okay. Let's see. Okay. And a question from AA. Is there a way I can expedite EAD after filing for asylum? Asylum to be filed after 1 year, that is 3 years later. In addition, can I get approved for F1 while I'm out of status?
You can't get approved for F1 if you're out of status. And expediting the EAD for asylum, if you look at last week's webinar, we had talked about ways in which you can contact the USCIS. So, and I think Kara posted that on the chat. So take a look at that webinar, and we have phone numbers, we've got email addresses. It'll tell you exactly what you need to do to contact your employer. Contact the USCIS.
The next question is from Towimbo. What state or office processes asylum cases faster?
I wouldn't say that there is right now, and I've said this before, in terms of processing time, everything is kind of in a flux. So, even if something is seemingly going faster now, you don't know what it's going to be like later. So there really isn't.
Okay.
And especially because of the asylum process, you have to go before a judge and things like that. So go.
This next one is from Siddharth Shanbag. I have a stamped visa on my old passport and is valid till June 2021. But as the passport was expiring, the I-94 dates were bound till August 2020. Couldn't travel out of country with new passport and get that updated due to travel restrictions. Hence, extension was submitted in August 2020 and still in progress, waiting for response. So would like to understand what steps would need to be taken if it crosses 240 days for I-94 date. Also, in this case, can I travel to India and come back on the same stamped visa?
Yes, you can. You would just take the receipt notice. Did he say he was filing for an extension, or he's filing for, filed for change of employer?
No, extension was submitted on August 2020 and
Okay.
still in progress, waiting for response.
So usually the visa is not going to be, it's usually the expiration of the visa is usually the expiration of the status. But if you've got some time in between, yes, you can travel out, and you should be able to come back in with a receipt notice as long as your visa is valid.
How much time do you have?
Till one. Oh, and one other thing, the 240-day rule, that's an I-9 rule. So the 240-day rule means if you filed for a timely extension of status in certain statuses, then you are allowed to continue working for 240 days. But remember, when you file for a change of status or an extension of status while you're currently valid in status, that means while that petition is pending, you are in what's called an authorized stay. So authorized status. So you're not accruing unlawful presence. So if the 240 days passes, but your petition is still processing, then you have to stop working, but you can continue to stay in the US. You don't have to depart.
All right, we've got some questions that will take us another 10 minutes. So we will request, if you have a question that you please send an email to us, info@challalaw.com, and be glad to respond as quickly as we can. But we will take the questions that we have here, including Srinivasa Vitla, whose question is on the chat. But I'll take first the AA question. My husband has filed for I-485 at the Texas Visa Center based on the approval of asylum on Pakistani passport. It has been 25 months already since it's filed. He filed it on his own, did not hire an attorney. Filing for an inquiry through an attorney will make any difference? Thank you.
Well, I won't say the inquiry. I think probably filing the asylum with an attorney would have made a difference in the initial filing. But if you look at our last webinar, we've got mechanisms in which you can call the USCIS, submit an inquiry. So take a look at that, and that should give you some guidance as to how you can follow up.
All right, next question is from AAA. I committed some offenses such public drunkenness. Will that affect my EAD approval after filing for asylum after 1 year period? These citations haven't been cleared yet. I missed court dates.
I'd have to look at it. It all depends on what state that violation took place in. So it's not a simple yes or no answer.
All right, Sri Kumar is back, says, thank you very much for your service. Applied AOS in October 2020, now waiting for biometrics appointment. My final action date is current. I have an important work in India in May. Is there any section or is there any action which I can do to get my EAD AP issued soon so that I can travel to India in May? Many people who applied after me who are not current got their AP EAD.
Why don't you try looking at our webinar from last week and we've got several suggestions as to how you can contact the USCIS and request kind of a expedited processing on your behalf.
Okay. Srinivas Vitla, my daughter is aged out 21 and we've got green card after she aged out. Is there any possibility to get green card for my daughter? Her current status is F-1 STEM OPT. I remember this question from the last week.
Yeah, not if she's aged out already. There would have been some things you could have done before she turned 21, but once she's turned 21, it's basically she's got to start the process anew.
Okay, Tawimba Hove is back. Can I go to school while I'm out of status?
Well, it depends on the state. There's some states that will allow it, some states that will not. So it depends on the specific states. Some academic institutions have that, we're not going to ask what your status is. Others are a little more, stricter in that application. So there's nothing on a federal level that says you can't. Well, you're not supposed to, you're in violation of your status, but schools, it just depends on the school.
Siddharth Shanbag is following up, the guy with the I-94 in 240 days crossing. He's asking, also adding to my question about, would there be a risk to my travel to India and back if I change an employer at this point?
No. Well, they're not going to adjudicate your change of employer until your extension gets approved. So what you would, you're probably, if you can premium your existing extension, then you can change employers and that shouldn't be a problem.
All right. Next question is from Rahel Ayalev. If you're traveling to your home country and need a H-1B visa stamping to come back, if you've never had traveled back since college, but currently working in the US and H-1B, what will the visa process look like? Will it be easier since the H-1B is already approved in the US and currently working?
Well, no, because the proclamation on temporary visas, non-immigrant visas is still in place. And so the only way you can override that is if you're eligible for Dropbox, which you are not because you've never had that visa before, or an emergency visa. And so if there's the type of work that you're doing is really critical, or the employer can provide a letter and kind of highlight how you need to come back, then you would be able to travel and process your visa. Otherwise, you will not.
The next question, can my employer file GC if I'm working with the employer on H-4 EAD?
Yes.
Next question from AA, my L-1B expired 3 years, but I'm still in the US. Can I ask my L-1B to sponsor me again?
Well, you've been out of status for 3 years. I would hope that the legislation changes because right now you're subject to the 10-year bar.
Next question is from Anil Manga. Can I use AC-21 while I file 485 previous employer and currently working for a different employer?
Can you what?
Can I use AC-21 while I filed 485 previous employer and currently working for a different employer?
Well, remember, if you had listened to my previous webinars, I would say that when you filed the 485, you would have had to have the present intent at that time to work for your employer that filed your adjustment. So if you weren't working for him, but you had planned to work for him, then your I-140's got to be approved, I-45's got to be pending for 180 days, and it's got to be same or similar work.
Okay. This anonymous, this Anil Mangas, could you please tell me if I can use AC-21 when I filed 485 previous? I think he repeated the question again. Here's the one from the FMLA. Yes, the employer has FMLA policy. My friend is the only one on H-1B. Due to the loss of job, they asked him to use FMLA without pay until 180-day mark is passed. Can he do this? Or will there be any question from USCIS during GC interview?
Yeah, see, here's where it gets really sketchy. FMLA or personal leave is something that the employee is supposed to ask for their benefit, not the employer is supposed to ask for their benefit, so they can circumvent the non-benching rules. They can put them down to part-time. I would rather do the part-time than do the under the Family Medical Leave Act. And part-time can be 15 hours per week.
Okay. Vignesh Reddy, I'm getting to your question, sir. You have a bunch of them on QA as well as on the chat. So I'm going to take it on the QA in the chronological order. So please bear with me. The next question is from AA. After filing for I-485, what does fingerprint fee was received status mean? What are the next steps?
You got to wait for your appointment.
All right. Raj Nagarajan, H-1B denied after RFE. Employer filed a new H-1 and back to status after a month. Unfortunately, the approved H-1 is not backdated. Will there be any impact on I-485 AOS?
It depends on how much of a gap you had between the expiration of your I-94 and the effective date of your H-1.
All right, there's a person who was asking about public drunkenness. He says the state is Pennsylvania.
Yeah, it doesn't tell me anything. That's too much. I can't research Pennsylvania's. That's too complicated an issue to answer on the Q&A.
Just send us an email to info@challalaw.com.
Yep.
Mayangela Basi. Good afternoon. My son has an OPT expiring in 1 month time. He attended New York bar examination in February. He entered another course last month at the university to have F-1 till July 2021, and the course will be over. Since he's looking for a job, are there particular firms that can sponsor, or can anyone do it? It seems not easy to have it.
Right. You have to find a law firm that's willing to sponsor a lawyer, which is not as, common as it is perhaps in other professions.
Okay. That gentleman on the question on drunkenness is, he says, Maryland and Pennsylvania are the states regarding school and public drunkenness issues while I'm out of status. I think once again, as we said, please send a detailed email so that, we can do the research and then, respond appropriately. Pradeep Kola, how to get access to previous webinars?
You have to go on YouTube and subscribe to the Challa Law Group, and then you can have access to all of them.
All right, anonymous attorney, can I use copies of my lost passport to file for asylum while waiting for the new one?
I would do that as long as yes, you could do that, and make sure you have proof that you've applied for a new one.
All right, an AA question. After being called in for the appointment for I-485 after fingerprint, when do we expect the green card?
As I've said previously, processing times right now are in a flux. You can ask me these questions in about 2 months, and I'd be able to give you something more clearly. Typically, after an interview, you get them within 8 weeks. But right now, everything is being delayed, so I don't expect that you would get them that quickly.
Okay. And then
Is this the last question?
there's one, and then there is Vignesh Reddy. He's got a bunch of questions there. This one from AA, is an approved perm required to be able to retain priority date when changing employer or need an approved I-140? If I-140 is required, is it needed to also spend 6 months with current employer before changing employer to be able to retain the date?
Yes. If you are changing employers before your current I-140 or 45 is pending, and I don't know if your 45 is pending or not. So let's say your 45 is not pending and you're changing employers. If you're changing employers, you have to go through the perm process again, right? Because there's no portability without the adjustment pending for 180 days. So you have to go through the perm process again, and you have to file a new I-140. You can retain your priority date from your previous I-140, but you have to file a new I-140. And yes, every time an I-140 is filed, whether it's an interfiling or whether it's a new filing, again, it's that that's when the time starts again for the I-140 to be approved 180 days before you can port.
Okay, this is the last question from Vignesh Reddy, and if we have not answered your question, please send an email to us, info@challalaw.com. I think we did say about almost 15 minutes ago that we have a bunch of questions to answer. So if you have submitted a question and we've not picked them, I apologize, but please do send an email and we'll.
Right. We got close to 100 questions today, so we're doing the best we can.
Mr. Vignesh Reddy, I'm working for a firm on H1 on F1 STEM OPT. They applied H1B and got it, but then I was laid off. I couldn't find another employer, and I'm still in your 60 days grace period. Can I change the status? I think we answered that one.
Did he say he's below the 60-day grace period or beyond the 60?
In US over the 60-day grace period, 2 months over.
Yeah, and I told you.
I think his follow-up is, can I use the same F1 visa to enter US after going back to home country?
Yes.
And then.
But you'd have to be enrolled, they'll ask to see your I-20. So you don't have to get a new visa if your visa is valid, but you have to make sure you're enrolled in a new program.
Seeking more clarification on my question, since I moved from F1 to H1 and now out of status, can I re-enter with valid F1 visa, which is still valid?
Yes, you can, because when you depart the United States and you re-enter, every time you enter the US and whatever visa you present, that is a status you hold at that time. So your previous H1 won't even be an issue. Now, later on, if you wanted to file for, you may be able to get a cap exemption. You may be exempted from the cap because if you're previously selected in the lottery. But when you depart and come back in on an F1, your H approval is no longer an issue.
Well, that's about the last question. And then to thank Mr. Venkat Pradeep Kolla for subscribing to YouTube. Pretty quick action from there. Appreciate it. And there's the link to the subscription to all the previous webinars is in the chat. So you can follow that and subscribe. And that's about all from me. Back to you, Lakshmi.
Yeah. Well, thank you so much, Shaker, for moderating this again today. And thank you all for joining. And as I stated, we've curated a bunch of information on the 2017 guidelines for AC21, travel, a lot of adjustment related issues that we'll be posting to our Telegram group. So I hope if you haven't joined, you probably want to join because we've got some really good information that we'll be uploading to that forum. And again, if you can share our webinar details and forum details with your friends, greatly appreciate it. You all have a safe week, and I look forward to seeing you next Wednesday. Thank you.
Bye.
Thank you, Shaker.
Good afternoon. Good day. Thank you, Lakshmi.
Bye-bye.